Hi, I'm Nick Critelli, Chair of the Iowa State Bar Association's Ethics Committee. Recently, the committee held an internet webinar where we discussed 5 new ethics opinions that deal with business relationships between lawyers. Hopefully by now you've had an opportunity to see the introduction segment and the segment concerning of consul relationships. Now it's time to turn our focus to the relationship known as Pro Hac Vice. Opinion number 1302 concerns the relationship commonly mislabeled as local consul. As you will see from the live presentation, there's no such thing as a local consul relationship. The proper term is Pro Hac Vice relationship. It's a complex relationship with lots of benefits to the client, but corresponding risk to both the Iowa lawyer and the lawyer granted Pro Hac Vice admission privileges. Let's look at the presentation.
Also, the Iowa Rules of Professional Conduct, Supreme Court Rule 32, deals with some of this. So we're trying to make some sense out of it. Let me set it up for you. We'll pick on California because we can. Why not? They'd probably pick on Iowa. We got a California lawyer who wants to practice or appear in court in Iowa. Under some state rules, they can. There's not a problem. They file an application. The Iowa lawyer, to the extent that there's a local consul rule, is a mail drop, and that's all there is. You hear that term, local consul. There are about 800 people on this webinar, and I'm going to go online to say, folks, there ain't no such thing as local consul. Get that term out of your mind, okay? We don't have that here. We have Pro Hac Vice consul, referring to the non-Iowa lawyer. Okay, we have Iowa consul who has a couple of additional duties that they undertake when they agree to sponsor a non-Iowa lawyer for temporary admission to the Iowa bar for a particular case. And that's what this is all about. So let's talk a little bit about it. Okay, Iowa Supreme Court Rule 31.14 is the operative rule, folks. Okay, pay attention. This is important. Okay, the rule says that the Iowa lawyer must actively participate in the matter as consul of record or co-consul with the non-Iowa lawyer. Okay, those of you who agree to be involved in Pro Hac Vice admissions, you got a duty here to actively participate. You can't mail drop. We call this the active participation rule. Secondly, the in-state lawyer who is co-consul or consul of record, and this is right out of the Supreme Court rule, for that client in the proceeding remains responsible to the client and responsible for the conduct of the proceeding before the court or agency. We call this the responsibility for conduct rule. So you see, Iowa lawyers, you've got a burden that's on you here that you have to deal with. Do not become involved in these engagements lightly unless you're willing to undertake these responsibilities and you have a good working relationship with your non-Iowa lawyer. Okay, so here's basically how it works now. Go back to our graphic. We got the out-of-state lawyer who now must associate with an Iowa lawyer, okay, who's responsible for the conduct of the litigation and actively participates in it. Then, and only then, can that non-Iowa lawyer appear and practice in the Iowa courts. So that's kind of the way that works, both in the federal and the state court. Federal court, because federal courts embody the state rules with respect to allowing those folks to participate. So that's the way that works. There's been a lot of controversy about it because non-Iowa lawyers don't understand it. A lot of Iowa lawyers don't understand it. My suggestion is that when you are asked to become involved in one of these relationships, simply send them a copy of that opinion of 1302. They'll get it. Okay, we'll be producing we'll take a part of this presentation. We'll also have more that will create a video, a YouTube video on it that you can send that link to these people and say, look, this is how this works. All right? Now, there's more to the story. Okay? Let's talk about the responsibility for conduct rule. You have a duty that's owed when you undertake this to both the client, okay, and to the court in this situation, because that practice is being allowed by operation of you. So you have a dual duty here. When you do this, you must forego your right as a lawyer to limit the nature and scope of your representation. Now, some of you are saying, what are you talking about? Take a look at Rule 32.1.2c. Under 32.1.2c, you have a right to limit what you will do for a client. You know, we do it all the time. In fact, we rarely enter into a general engagement. Almost all of our engagements are limited in scope. We have a scope of work section in our engagement letters. We're going to provide these services for you. And we number 1 through 18 or whatever it is. You'll see one of those later on in this presentation. Those are limited, okay? You can't do that in the Pro Hac Vice situation. You cannot limit your responsibility for the conduct of that litigation. Okay, that's one of the things you forego. Okay, secondly, Iowa lawyers have a collaboration, consultation, and advisory responsibility to clients, okay, which includes the obligation to engage in goal setting or strategic planning. That's Rule 32.1.4a.2. Okay, this is your obligation to consult and collaborate with the client. Now, a lot of times under some Pro Hac Vice rules, under the mail drop theory, you never meet the client. Well, you can't do that here, okay? You have to engage in them because you have an obligation to engage in that dialogue and an obligation under 1.4b to educate the client, okay? Secondly, okay, you can't delegate that obligation. Okay, the rule prevents the obligation from being delegated or otherwise limited by the professional rule 1.2c. So you're in the mix, friends. You have in the building and the delivery of that legal product. That's why I tell you, get rid of that term local counsel. Okay, at best you're co-counsel, and you have to deal with it that way, and people have to understand what that is, because that's what they're requiring of you. You could be sanctioned in those situations. These three things are critical with respect to your relationships. So keep that in mind, okay? Now, active participation rule. It complements the full conduct rule. We do recognize, and this is out of the opinion, we recognize there are certain limited situations where Pro Hac Vice lawyer can operate without the presence of an Iowa lawyer. And it always revolves around depositions, okay? Why, if it's a Texas case and a Texas doctor and it's filed up here in Iowa, why should that client have to pay that Iowa lawyer to go all the way down there to sit and watch a deposition when the local Texas lawyer could do it, or California lawyer, whatever it is? Well, under the active participation rule of other states that have this, the question is, do you have to do that? What are depositions? Well, as you know, depositions are basically the start of the trial. That's testimony, okay? We pulled opinions from other jurisdictions. Some say, yes, you have to be there for all purposes. If you don't, then that's the unauthorized practice of law by that non-Iowa lawyer, and you facilitate it when you allow that to occur, so you're facilitating the unauthorized practice of law. And there's disciplinary cases on this, not in Iowa, thank God. Okay, other cases, there's opinions say, well, you know, that's a waste of client's time. We kind of hit a middle line here. What we said is, we're going to leave it to the Iowa lawyer to use their best judgment to determine what parameters will be. If you think that your participation is required under the rule, then do it. If not, then tell us why, put a memo in your file as to why and go down the road. If it's purely a discovery deposition, now I know there's no such thing as discovery, but we all know there's some depositions that are going to be used to perpetuate testimony or will likely be used in court that you think you need to be at, then be there. Okay? If not, then use your judgment and your discretion. At some point, we have to rely on Iowa lawyers to make good opinions. So there you go. Am I responsible for Pro Hac Vice lawyers' malpractice? That ought to scare everybody. Well, no. Okay, I found a case for you, okay, out of the 8th Circuit, a rule similar to ours dealing with Minnesota that says that we have no duty on local counsel to supervise performance of that counsel. In other words, we have duties for the conduct and participation, but under Macabre, we don't have duties to supervise their performance. Now, I don't know, folks, that I would bet the farm on this one, okay? There's a case there that might help you. Bottom line is, if you're a co-counsel, you probably are going to have some responsibility, particularly if you sign something. And there are a lot of Rule 11 cases out of the Northern District in Iowa and Southern District that say, hey, you sign it, you're on the line. I wouldn't bet the farm on this. All right.
I truly hope that clears up a lot of the misunderstanding regarding the Pro Hac Vice relationship and local counsel. The next segment deals with Opinion 1303, the contracted lawyer or law temp relationship. Thanks for watching. If you have any questions or comments, please feel free to contact me at nick@critellilaw.com, nick@critellilaw.com. Until then, have a good day.